Good day, class. Today we will talk about Chapter 2, the nature and effects of obligation. Now, Chapter 2 covers a vast number of articles. It covers Article 1163 until Article 1175. So let's go now to Article 1163. Now, it states there that every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the party requires another standard of care. Now, Article 1163 talks about one of the obligations of the obligor of the or the debtor in specific real obligation. Now, what is diligence? So, diligence, that is the care or caution or the attention and care required from a person in a given situation. Now, what kind of diligence does the law require in cases of a debtor or an obligor? Now, Article 1163 talks about diligence of a good father of a family. So that is what usually what a father does, or how an ordinary person takes care of the property as if it is his own. So that is the diligence of a good father of a family, or diligence pater familias. Now there's also what you call due diligence. So this is the lowest form of diligence. That is the diligence reasonably expected from and ordinarily exercised by a person who seeks to satisfy a legal requirement or to discharge an obligation. So that is due diligence. Now we also have this extraordinary diligence. This is the highest form of or highest kind of diligence because it requires extreme care that a person of an unusual prudence exercises to secure rights or properties. Now, in cases of specific real obligation, what is required again is the diligence of a good father of a family, or diligence pater familias. So again, when we go back to what is a real obligation, that is an obligation to give. Okay, so general rule, you have to take care of the thing with proper diligence of a good father of the family. However, 1163 provides for exceptions to the rule. So what are those exceptions? Number one, when the law requires another standard of care. So as I have said earlier, there are instances where it is not the diligence of a good father of a family is required. Uh, there is also this utmost diligence or extraordinary diligence. Now, what are examples of cases where the law requires utmost diligence or extraordinary diligence? In cases of contract of carriage. Contract of carriage, that is the obligation of the driver to safely carry the persons and properties who are riding in his public transportation from their origin to their destination. Now, that is specified under Article 755. So, all common carriers, or what we usually call public utility vehicles, they are required to exercise utmost diligence or extraordinary diligence. Why? Because in contract of carriage, what you carry are the lives of people and the properties of other people. So that is why it is required, they required utmost diligence. Now, we also have, under the general banking laws, banks are required to exercise high standards of integrity and performance. They require diligence more than the good diligence of a good father of the family. So, what is more than diligence of a good father of a family, that is extraordinary diligence. Now, why is it necessary for banks to exercise extraordinary diligence? Because, of course, banks, now what do? They take care, no, they are the depository of the money or property of the people or their clients. So, it is also necessary that they exercise extreme or extraordinary diligence. Okay. So when you talk about diligence, there's also negligence. Okay. So, however, we will discuss later. There's no actual uh, definition of diligence of negligence because it depends. It's a case to case basis, basing on the circumstances, nature, time, and place of the obligation. Okay, so again, general rule, it is the duty of the obligor to take care of the thing with proper diligence of a good father of a family. And number one exception to the rule, when the law requires another standard of care. Another exception provided under Article 1163 is when the stipulation of the parties require another standard of care. Now remember that in the first exception, it is the law that requires. Now, it's the law that requires another standard of care. However, in the second exception, it is through a stipulation. It is when you say it's the different standard of care was required through a stipulation, it was agreed between the obligor and the obligee. So again, that is Article 1163. Now we go to Article 1164. What this 1164 states, a creditor has a right to the fruits of the thing from the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Okay, so Article 1164 talks about the rights of a creditor. So that is the right of a creditor. So, however, it also talks about an obligation of the debtor in a specific real obligation. So what is the obligation of the debtor in 1164? That is the obligation to deliver. That is the obligation to deliver. So what do you mean by delivery? So delivery is a formal act of transferring something such as a deed, the giving or yielding possession or control of something to another person. That is the legal definition of delivery. Now, there are certain kinds of delivery. So, we have the actual delivery and the constructive delivery. Now, actual delivery usually happens when you deliver a, what do you call this? A personal property. Why? Because a personal property is a movable property. You can simultaneously or actually deliver the said property. Now, when you say actual delivery, is the act of giving the real and immediate possession to the buyer or the buyer's agent. So, giving real and immediate possession. So, for example, the act of delivering a cell phone. Mr. A delivers a cell phone to Mr. B. That is actual delivery. Now we go to another kind of delivery, which is constructive delivery. When you say constructive delivery, that is an act amounts to a transfer of title by operation of law when actual transfer is impractical or impossible. Now, constructive delivery usually occurs in cases of immovable or real properties. Why? Because if you go to the law on properties, immovable properties include lands, vehicles, ships, or anything that is attached to the ground. Those are considered immovable or real property. So, when you want to deliver an immovable property, you do it by constructive delivery. So, because actual transfer is impractical or impossible. So, how would you transfer a land? Actually. No, you cannot just carry it and give it to the obligee, right? So, you do a transfer by operation of law. So, how do you do it? By signing a deed of sale, that is a transfer, and the execution of such deed of sale through a public instrument. When you say public instrument, that is a notarized document. So, that is through constructive delivery. So that is constructive delivery. Executing a deed of sale, or in cases of delivery of houses, you have the constructive delivery, the symbolic turning over of the key. Now that is what you call constructive delivery, because the actual transfer is impractical or impossible. So again, it is a duty of the obligor to deliver, whether actual delivery or constructive delivery, the fruit of the thing. Okay. So that is the right of the obligor. Now, Article 1164 talks about the fruits. No? So, what do you mean by fruits? Does it literally mean those fruits growing out from the tree? So, under the law on property, there are three kinds of fruits. We have natural fruits, industrial fruits, and civil fruits. Now, what do you mean by natural fruits? So, those are the spontaneous product of the soil and the young and other products of animals. So, what do you mean by that? A mango tree with a mango, that is a natural fruit. Eggs from a chicken, that is a natural fruit. Piglet from a pig, that is a natural fruit. Now we have industrial fruit. Oh no, I think the mango example was wrong because it's not actually a natural fruit. However, if it was just is a wild mango, then that is considered a natural fruit. However, because you compare it with industrial fruits. Now, industrial fruits are those produced by lands of any kind through cultivation or labor. So, when you talk about industrial fruit, there is human intervention. Okay, there's human intervention. And such as mango. The mango, because usually it grows in plantation, there is human intervention. Or vegetables, grapes. These are what you call industrial fruits, because it is cultivated by labor. There is human intervention. And then we have civil fruits. These are the rents. Rents of buildings, prices of lease of land, and other property, and the amount of perpetual or life annuities or other similar income. So these are fruits arising from land, buildings, houses, or rents. So that is what you call the civil fruits. Now, under Article 1164, what does it say? The creditor has the right to the fruits of the thing from the time the obligation to deliver arises. Okay. So, for example, Mr. A has the obligation to deliver a car to Mr. B on February 1. Okay. Oh no, not a car because it does not have fruits. For example, an obligation to deliver an apartment. Okay. A building with tenants. So, Mr. A, the obligor, has the obligation to deliver to Mr. B an apartment now with tenants on February 1. However, Mr. A was not able to constructively deliver the said uh, property because he was out of town. So he constructively delivered the property on March 1. Okay? So again, the time that the obligation to deliver arises started on February 1. However, the constructive delivery happened in March 1. Now, who has the rights over the rents on the month of February? So, under 1164, it is actually the creditor. Okay? However, the creditor cannot collect the rents for February if he had no real right over it because he had no real right over it until the same has been delivered to him. So, for example, the collecting of rents for the month of February will be on March 5. However, the constructive delivery happened on March 10. Mr. B cannot collect on March 5 because he has still no real right over the said property because it was not delivered to him. However, when it is turned over by March 10, he now has the real right to collect the rents or the civil fruits of the said thing which was delivered to by Mr. A. So that is 1164. Okay. So let's go to 1165. Um, okay. 1165 states that when what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1160, may compel the debtor to make the delivery. So Article 1165 talks about um, right. Specific performance. Now, that is the right of the creditor in a real obligation to compel specific performance. So, that is under 1165. So, what are the rights provided by him under 1170? So, we go to 1170. Those who, in the performance of their obligation, are guilty of fraud, negligence, delay, and those in any manner contravene the tenor thereof are liable for damages. So 1165 states there that aside, in addition to the right granted to him by Article 1170, that is the right to damages, he may also compel the debtor to make the delivery. So that is in cases of a determinate thing. Now we go back. What is a determinate thing? That is what is particularly designated or physically segregated from all the others of the same class. So I have said in my former lecture, when you talk about determinate thing, the delivery of iPhone 12 with serial number 1234, that is a determinate thing. So what do you mean by specific performance, no? So that is the right of the creditor to compel the debtor to make the delivery. So you can compel, no? For example, Mr. A promised to deliver iPhone 12X with serial number 1234 to Mr. B on February 1. However, Mr. A failed to deliver the said iPhone, the said determinate thing, to Mr. B on February 1. On February 2, the right of Mr. B arises, the right to damages and the right to compel specific performance for failure to deliver the determinate thing. So that is what you call by specific, that is what you mean by specific performance. Now that is Article 1165, paragraph 1. Now we go to paragraph 2. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. So what is Article 1165, paragraph 2? It talks about indeterminate or generic thing. So again, what is an indeterminate or generic thing? For example, an iPhone 12. So that is an indeterminate or generic thing. Or for example, a cell phone. No? When you say a cell phone, that is an indeterminate or generic thing. It is not specific. So, the creditor also has the right to compel the debtor to deliver the indeterminate or specific thing at the expense of the debtor, of course, at the expense of the debtor. So that is a right of the creditor in cases of generic or indeterminate real obligation. Now, what is the third paragraph? If the obligor delays or has promised to deliver the same thing to two or more persons who does not have the same interest, he shall be responsible for any fortuitous event until he has effected delivery. So, what does the third paragraph states? No, in cases of the obligor fails to deliver, no, fails to deliver a specific thing on a specific period, that is delay, or he has promised the same thing to two or more persons. So, for example, he promised to deliver iPhone 12 serial number 1234 to Mr. A, and he also promised iPhone 12 serial number 1234 to Mr. B. So he promised to deliver the same thing to two or more persons who does not have the same interest. And in case there is loss due to a fortuitous event, he shall be liable, okay, until he has effected delivery. So the loss of a thing due to fortuitous event, if there was delay on the part of the obligor, or that he promised to deliver the same thing to two different persons, he shall be responsible to deliver. He shall be responsible for the object or for the thing in cases of fortuitous event, because advance info. In cases of fortuitous event, the obligor shall not be liable for the loss, except in cases provided in Article 1165, paragraph 3, in case of delay, or in case the obligor promised to deliver the same thing to two different persons. Okay, so that is Article 1165. And then let's go to Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not be mentioned. So what do you mean by accessions? Now, these are things that are naturally or artificially attached thereto. So if you try to look at the examples in your book, it states there earphone of a cell phone, but I believe at present earphones are not considered accessions. No, they are not considered accessions, and sometimes they are even not considered accessories, because you have to buy it separately from your phone. Okay. So again, by definition, when you say accessions, these are naturally or artificially attached thereto. And when you say accessories, they are not incorporated or attached. You know, so they did not come from a they are not attached. No, they are not attached to the thing. However, they are still necessary or convenient for the perfection of another thing. Now, for example, you have your cell phone. What is the accession? What are the accessions of a cell phone? You have the battery, no, for example, because it is artificially attached to the phone and it doesn't work when there is no battery. So that is an accession. When you say accessory, for the necessary or convenience for the perfection of the cell phone, you have your earphones, you have your SIM cards. These are your accessories. Now, under 1166, you have to deliver the accessions and accessories even though they may not have been mentioned. So, for example, in an obligation to deliver a cell phone, it is usually understood that you include a battery of the cell phone. You also include the earphone, unless there is a disclaimer. Okay, so unless there is a disclaimer. So that is Article 1166. Now we go to 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. So this is in cases of obligation to do and obligation not to do. Okay. So the first paragraph states there an obligation to do. So for example, Mr. A was obliged to paint the wall of Mr. B on February 1, and Mr. B already bought the paints and everything, all the needed materials for the painting. However, Mr. A failed to show up, and he showed up 3 months after the paints were already expired, and everything gone. So under Article 1167, because Mr. A failed to do it, he shall Mr. B has a right to demand that the same be executed, but at the cost of Mr. A. So it would mean that because Mr. A failed to paint the wall on the agreed time, then Mr. A would then execute the painting or the obligation at his cost. So he has to pay for everything. So that is Article 1167, Paragraph 1. The failure to comply an obligation to do. Now, Paragraph 2 states the same rule shall be observed in cases of an obligation not to do. So, for example, Mr. A was a tenant of Mr. B. Now, under the contract of lease, Mr. A was not allowed to put up a fence in front of the rented house or the leased house. However, Mr. A put up a fence despite the agreement between Mr. B not to put up a fence. So, under 1167, paragraph 2, the fence should be, tear down, should be removed at the expense of Mr. A because of failing to comply with an obligation not to do. Okay. Furthermore, it may be decreed that what has been poorly done be undone. So, for example, in an obligation to paint, Mr. A was obliged to paint the wall red. Okay. However, when Mr. A painted the wall of Mr. B, instead of red, it was really light, and at some point it became pink in the eyes of Mr. B. So, Mr. B can go to court because it says it may be decreed. So it may be Mr. B can go to court and ask the court that Mr. A what do you call this? Removes the paint and then does what he was obliged to do. Okay. So again at the expense of Mr. A. Okay. So that is Article 1167. Article 1168, still this is an obligation not to do. When the obligation consists in not doing and the obligor does what he has been forbidden him, it shall also be undone at his expense. So that is what I gave an example earlier in case of an obligation not to build a fence in front of a leased property. However, the lessor the lessee built a fence in front of the leased property, then he shall undone it at his expense. Okay. Okay, so those are Article 11 1163 to 1168. So we will just cut 1169 because it's kind of long. So if we want to summarize what are the obligations of a debtor in real obligation that we have just mentioned earlier, in specific real obligation, that first is the obligation to deliver a specific or determinate thing which he has obligated himself to give. to take care of the thing with the proper diligence of a good father of a family, and to deliver the accessions and accessories, and to pay damages in case of breach of obligation. So that is in cases of specific or determinate real obligation. In cases of generic or indeterminate real obligation, the obligation of the debtor is to deliver a generic thing which must be neither of superior nor inferior quality. Although, yes, that is provided under Article 1246. No, that would be later on. And then to pay damages in case of breach of obligation. So that is provided under Article 1170. So always when there is breach, there is liability to pay damages. Now, what are the rights of a creditor in real obligation in cases of specific or determinate real obligation? Number one, to compel specific performance. That is in Article 1165, paragraph 1. Number 2, to demand rescission or cancellation of the obligation. That is in Article 1246. No, Article 1191. We will discuss that later on. To recover damages in case of breach. That is still in 1170. Now, what are the rights of the creditor in case of an indeterminate real obligation? Number 1, to ask for specific performance. That is 1165, paragraph 2. Number 2, to ask what the obligation be complied, to ask that the obligation be complied with at the expense of the debtor. That's what we discussed earlier. Yes. And then to recover damages in case of breach of obligation. So, still Article 1170. And then we also have the rights of the creditor in personal obligation. So, for obligation to do, that was what was specified under 1167, that the obligation be performed at the expense of the obligor, or to ask what has been poorly done be undone, and again to recover damages. Now, in cases of a negative personal obligation or obligation not to do, that is specified under Article 1168, to have it undone at the expense of the obligor and to ask for damages. Okay, still under 1170. Now, Article 1169 until 1175 will be discussed in another video lecture. Thank you and have a good day.